Hi everyone, thank you for tuning in to this segment of COVID Conversations with Lawyers. My name is Shi Hui, and together with my friend Wei En, we'll be hosting this segment on the impact of COVID-19 on international arbitration together with Mr. Daryl Chew. Daryl is a partner in the International Arbitration practice of Shearman and Sterling, and is also the head of the firm's Singapore office. He has advised and represented clients in arbitrations conducted under the rules of all major arbitral institutions. These involve a wide range of applicable laws and venues, arising from energy, construction, mergers and acquisitions, joint ventures, and general commercial disputes. Daryl also serves as the presiding arbitrator, co-arbitrator, and sole arbitrator in institutional and ad hoc arbitration proceedings. Hi Daryl, how have you been? Maybe you can tell us a little bit about yourself. When did you graduate from NUS?
Hi guys, I've been well, and thank you Shui and Wei En for the opportunity to share, and my congratulations to the NUS team for developing this meaningful initiative. Quick introduction of myself. I graduated from NUS in 2006. I clerked for the Supreme Court of Singapore, and then I joined Shearman and Sterling in 2008. I spent some time in the firm's other offices, including in Paris, and I currently serve as the managing partner of the Singapore office, and I head the International Arbitration Group in Singapore.
So Daryl, maybe you could share with us what a typical workday is like for you.
Sure. Well, I don't have a real typical workday. I think my day can vary broadly based on the needs of my clients. The majority of my time is spent on casework, drafting submissions, developing strategy, interfacing with clients. Also a fair amount of time spent on management-related tasks, business strategy-related matters, or coordinating CSR initiatives. I used to spend about 1/3 of my time traveling, but now that I'm working from home, I try and spend more time with my 2 kids and get some exercise, which I've tried to do a bit more of since the circuit breaker started.
Maybe we could just start off this interview with asking you what are some trends that you actually have observed in the attitudes of the disputants and clients towards arbitration when you first entered your arbitration practice as compared to today?
Well, use of arbitration has grown exponentially since I started practice. It's now effectively a default dispute resolution mechanism in complex cross-border transactions across the region. I've seen the growth of arbitration in Asia as the center of gravity of disputes shifted from the west to the east. Disputes that 10 years ago would have been seated in London or in Paris are now being resolved in Singapore and in Hong Kong. And this is borne out by Queen Mary University surveys, which sees Singapore consistently ranked among the most popular seats globally, and the SIAC caseload statistics, which have increased steadily year on year. I would say arbitration remains a rapidly developing field with many innovations in arbitral rules and new protocols across the region. It reflects evolving paradigms designed to find ways to meet the changing needs of users, and it remains one of the areas that I think many younger lawyers hope to break into and specialize in.
Okay, I'll now pass the time to Wei En, and he'll bring us through this segment that we're looking at trends and how the arbitration practice has been affected by COVID-19.
Thanks, Shi Hui. And so Mr. Chew, just now, so you mentioned that the attitude of disputants and clients toward arbitration that is becoming more and more popular nowadays. But we're just wondering that, especially in this time that we are living in with the COVID-19 pandemic, which has such significant impacts on trade, markets, supply chains, and businesses, which is going to bring about an increase in disputes and litigation. We're just wondering, has this altered the approach or attitude of clients toward dispute resolution processes in general, and also looking at arbitration in particular?
Well, clients today face pressures on many fronts. Initially, there were widespread manpower and supply disruptions. There were restrictions on operations, changes in law. And as the pandemic now evolves, we start to see the insolvency of different players, contractors, suppliers. We see liquidity and debt pressures, significant market movements. And I think this confluence of events has impeded or delayed the performance of many contracts. Many obligations have been impractical to perform to varying degrees. And you're right, in times like this, it's not uncommon to see opportunistic behavior. We've seen parties seeking to extract a commercial advantage, attempts to renegotiate or exit contracts. We have seen genuine force majeure claims, of course, but also those designed to gloss existing breaches. Joint venture partners and shareholders have been in dispute. I would say, despite the lapse of some time since the onset of the pandemic, there is still significant uncertainty. I mean, many are still asking the same questions. How long will these restrictions last? When will it be business as usual? How do I manage my contractual relationships and risks? And the reality is businesses have to make commercial and legal decisions without full visibility on how things will develop. And is there a wave of COVID-related inquiries? Yes. But the focus of the majority of clients appears to be assessing their rights and their obligations and weighing the options available to them, rather than pursuing immediate claims of breach and enforcing the letter of the contract for now. In questions we have received range from, will positions taken by my counterparty trigger defaults under related contracts? Can my counterparty renegotiate the terms on the basis of an MAC provision? Everyone is living through the same experience to different degrees. And due to this shared crisis, shared experience effect, many parties appear willing to discuss options and workarounds. So we've seen more flexibility, we've seen shared empathy and common uncertainty for now, right? Will some of these crystallize into large litigations and arbitrations in the future? Some of them have, and some of them undoubtedly will. In many cases, the gap cannot be bridged, the losses accumulate, and parties are compelled to take legal action. But arbitration continues to be a key mode for resolving many of these disputes.
Okay, thank you. And also just now, so building on what you've mentioned, there's this question that all of us are asking, which is when can businesses go back to normal? And yeah, the legal systems and the court are also affected because initially, once the pandemic hit, many courts around the world closed as a result of government measures to try and reduce the spread of the virus. And as a result, hearing dates are postponed and only more urgent cases are being done through virtual hearings nowadays. So I was just wondering, have you ever been part of a virtual hearing? And perhaps what are maybe some key points that make it different from a physical hearing?
I have. Virtual hearings have now become, in some ways, the new normal. A couple of points to bear in mind. The first, I would say, is due process considerations, right? This includes ensuring that parties have reasonable access to the necessary technology, adequate time to prepare for the virtual hearing. Another key point is the importance of adapting advocacy to this new medium. I think it's important to be conscious of the diminished attention spans of an audience when addressed by video. I mean, many of you may have experienced Zoom fatigue, and this is the subject of various studies. And it's key to calibrate your oral argument to this new mode. And here, the fundamental imperatives of good oral advocacy, including focus, distillation of the wedge issues, are all the more important. And we all need to adapt our presentations accordingly. I guess another aspect is witness examination. it may be more difficult to assess witness credibility remotely, and this is primarily due to digitized filters of voice and tone over platforms like these. There are more distant facial expressions, you see less of the nonverbal cues, and of course you have potential IT interruptions that can disrupt the flow. And I guess a final point I would raise is the heightened importance of confidentiality and taking steps to ensure the security of communications, of platforms, and to preempt cybersecurity risks.
And so also, would you say that this pandemic has forced the lawyers, arbitrators, and arbitral institutions to be more cost and time effective through this digitalization of the processes?
Yes, it has. And at a macro level, the pandemic has accelerated many global disruptive megatrends that already were well in motion, right? You have decoupling, localization, you have consolidation across different industries, you have increased regulation, economic fragility, and this increased reliance on technology and automation is one of the obvious trends that have been accelerated. And the forced transition, I would say, has generally been positive for the efficiency conversation and the acquisition of new skills, development of expertise and protocols across the world.
Yes, thank you. And just one last question for me. So building on from what you have mentioned there, so do we think that these impacts that we have seen as a result of the pandemic, do you think they are going to impact the future of international arbitration and just dispute resolution in general, even in the post-pandemic environment? Or is this just a reaction that we're taking with the current situation right now?
Well, for many years now, there has been an overarching imperative and drive towards greater efficiency in arbitration. Post-pandemic, there will be a permanent change in mindset, and we can expect more regular use of remote hearings and technology-assisted platforms. And like this interview, I think virtual hearings will be more commonplace. We will not necessarily need to convene parties from 5 different jurisdictions to attend an in-person hearing with all the attendant scheduling constraints. It will be more challenging for recalcitrant parties to try and delay proceedings given the broader suite of technological alternatives. There will be new tools for managing documentary evidence remotely, and all of this bodes well for efficiency, for flexibility. There have also been refreshing out-of-the-box proposals, such as the possibility of asynchronous hearings, so parties recording their submissions in advance. And these renewed conversations on innovation are to be welcome. That said, post-pandemic, I expect there to be at least some reversion to in-person hearings in the longer term, especially if there are strong objections from one party to a remote hearing. And as I mentioned earlier, I think there are limitations to a virtual hearing and in-person engagement that cannot be easily replicated through technology.
Thanks for those questions, Wei En. Maybe just to round up the interview, I'll now be asking Daryl about more perhaps broad-based questions as we look towards the post-COVID world in light of what he has said thus far. So, Mr. Chew, just now you actually mentioned that Singapore was one of the perhaps more popular arbitral seats around the world. As a consequence of COVID-19, do you think there are some, or rather what new qualities will make an arbitral seat attractive over the traditional qualities associated with arbitral seats, for example, like Singapore?
Well, our world today is characterized by COVID-19 pandemic concerns, a more uncertain and volatile geopolitical landscape. We see increased polarization and nationalism. And if you put yourself in the shoes of a business owner in this context, where do you want your disputes resolved in the longer term? I think three attributes of a seat will be key: security, stability, and sustainability. On security, in the wake of the pandemic and subsequent waves of infections, users will prioritize seats that are best able to address their health concerns and guarantee safety to participants in the arbitration process, whether it's counsel, witnesses, arbitrators. And practically, this means a reliable health system and a track record of successfully containing the pandemic. Also factors like easy accessibility, ability for judicial functions to remain open and operational. And the concerns extend not just to security of the person, but also online security. So technological infrastructure to protect data, to prevent cyber attacks, these will all be important. The second attribute, stability. Users will be inclined to select a seat which offers a stable business environment and predictability, neutrality, and one that's not frequently entangled by political skirmishes that could affect the perceived fairness or impartiality of the system supporting arbitration. And finally, sustainability. There are a few different aspects to this. I think users will generally value trusted government and systems which are adaptable and resilient, that have a track record of working through crisis. I mean, no one can predict the next crisis, but having foresight, discipline, transparency by the relevant institutions will help assure users of stability. From an ethical perspective, I think the seat should be supportive of professional and other norms governing the behavior of arbitrators and counsel, and in a way which embraces a diversity of legal and cultural traditions. And finally, innovation and diversity. Right? Users have now eschewed the one-size-fits-all model. So the seat and institution should embrace culture of innovation and diversity of different options and continually invest in improving and meeting the needs of users. To sum up, and to answer your question, Singapore has demonstrated many of these features, and it's well placed to continue to serve as a dispute resolution hub. Just very quickly on each of the 3 points on security, I think we've thankfully managed to contain the pandemic with reasonable success and a well-resourced health system. We must remain vigilant, but daily cases have come down and measures are in place to manage subsequent waves. And our judicial functions remain operational throughout this period. And online security continues to be a key priority. Right? On stability, Singapore is well known for its stable business and political environment. Its neutrality within Asia has contributed to its popularity, and it's vindicated by the SIAC statistics. I think in 2019, parties from about 60 jurisdictions chose to arbitrate at SIAC with a sum in dispute of around $8 billion. And this was a 15% increase from the year before. And on sustainability, Singapore has embraced innovation. It presents a diverse range of dispute resolution options, including the SICC, SIMC. We hosted the global signing of the Singapore Mediation Convention. We've established the Maxwell Chambers facility, which is Asia's largest fully integrated dispute resolution complex. And the SIAC itself has pioneered many innovations, whether it's the cross-consolidation protocol, the SIMC has promoted online mediation, developed a COVID-19 protocol. I guess a very final quick point on geography, right? Pre-pandemic, the debate centered on globalization. But there is now an increasing premium placed on physical proximity, right? Many companies are now looking to regionalization of their supply chains and operations. Why? Because physical proximity matters. And in this context, Singapore sits within a region with tremendous growth opportunities in the next decade. We are in the backyard of Indonesia, Vietnam, Philippines, Thailand, countries which expect significant foreign investment, economic modernization. We are stone's throw away from China, India, and we maintain strong relationships with these countries. So in summary, I would say very few jurisdictions can boast this blend of security, stability, sustainability, geographic proximity, and coupled with fairly widespread acceptability across the East and the West. I think all of these factors have contributed to Singapore's popularity as a seat, especially for disputes with a nexus to Asia.
Thank you, Daryl. Maybe just as a last question to round it all up, as we move from even the conversations about COVID and the impact that it has on arbitration to different modes of dispute resolutions in general. We see that mediation and arbitration has actually adapted pretty well to the changing circumstances brought about by COVID-19. Do you think that the pandemic will have actually a longer-term impact on clients' preferences when it comes to different modes of dispute resolution?
Well, in my experience, many clients, particularly in the wake of the pandemic and financial pressures, are now open to less confrontational forms of dispute resolution, including mediation or neutral evaluation. And this really reflects an increased appetite to avoid protracted litigation if possible, which can take its toll in terms of cost, in terms of time, management bandwidth. It detracts from running the business.
I see. So, if I build upon that, would you say that the world is actually moving towards appropriate dispute resolution, right, which is otherwise known as ADR 2.0, which is actually a term first maybe spoke about by Professor Joel at NUS. So this means that dispute resolution processes like arbitration, like mediation, like litigation, they actually do not strictly compete with each other, but actually are presenting different options depending on the different objective of the users. So what do you think? Is the world indeed moving towards ADR 2.0?
I think that's right, and I like that term. I think it stems from a growing recognition that these are not mutually exclusive options, but reflect a more diverse range of modes to resolve disputes, to meet different needs at different phases of a dispute. But they're all directed to finding efficient and effective ways of resolving disputes fairly and transparently, and with a reasonable degree of predictability in outcome. In some cases, the fact that there was an arbitration clause did not prevent the parties from agreeing a less confrontational process beyond the usual choices. I had a recent matter. There was about $200 million at stake, and both parties agreed to engage a neutral adjudicator to provide a non-binding opinion on the merits of certain key issues based on written submissions. It was really an extra contractual process. The opinion was provided and the parties settled on the basis of that opinion. So the outcome was the dispute was resolved within 3 to 4 months at a mere fraction of the cost. So this clearly is a success story, and it may not suit all disputes, but it does reflect the value of a neutral, independent perspective and the possibility of moving beyond the usual mediation arbitration dichotomy to meet the needs of the parties and the dispute.
Okay, thank you, Mr. Chew. And from everyone at COVAID and NUS Law, we really would like to extend our thank you to Shearman and Sterling, as well as you, Mr. Chew, for taking part in this interview about COVID's impact on international arbitration and beyond.
Thank you, Shi Wei, and thank you, Wei, and it was a pleasure.